A lot of action today in Washington, D.C. It was the Robert Burr. That would be interesting. That I think would have been more fascinating. Robert Hur testifying before Congress in the Biden documents case. He was the special counsel. Attorney Jeremy Rosenthal is joining me now, founder of TexasDefenseFirm.com. Jeremy, it's great to have you back on the show.
Thank you. Thank you for having me.
Now, I know you're busy. I don't know if you had a chance to see any of Counsel Hur's testimony today.
Well, how good of a lawyer would I be if all I was able to do was sit there and watch blow for blow everything that happened? I practiced a little bit of law today, but practice makes perfect, right?
Right.
So yeah.
I watched maybe about I had it on in the background for a while, but I watched maybe half an hour continuously while I was eating lunch. And I mean, this is exactly what you might expect it to be. A lot of political theater, grandstanding. The answer is far less important than getting some FaceTime asking questions by the congressmen and women. Pretty pointless. I think that Robert Hur did a good job defending his conclusions by stressing that he did not exonerate Joe Biden, defending the rationale for including the remarks about his age in the document. But really, I mean, the Democrats were there to ask questions about Donald Trump, and the Republicans were there to try to make Joe Biden seem incompetent. From what you saw, from what you've seen in the summaries, probably reaching the same conclusions.
Political theater. You do have a special prosecutor who's, I mean, that part of it from a legal standpoint is kind of interesting to see what all went into his decisions and to what all went into his rationale. I mean, from a legal standpoint, the memory issue, I think the lawyers, we tend to be a little more clinical about these things. But I think that what we do is that we kind of look at it from intent standpoint, right? What's the intent of the parties here? What's the intent of a person who is acting, and how does memory affect his intent? Which is different from competency, right? That's another football that gets punted around quite a bit.
Right.
Is somebody competent to stand trial or incompetent to stand trial, which is different than somebody's memory affecting what it is that they're intending doing. When you are incompetent to stand trial, you just understand what's going on. You're not able to have a lawyer about how, okay, here's the witnesses that we can call, here's the things that we need to do. That part to me is pretty interesting, but yeah, I don't think anybody got any of that today. I think you're right. I think this is all just sort of a lot of theater.
And it's normally, I would guess, not up to the prosecutor to determine if a subject is competent to stand trial. That would be left up to perhaps a judge or an independent evaluation.
That's right. So in the state of Texas, for instance, we would file what's called a suggestion of incompetency, which says my client can't really participate in his own defense. Part of the standard is that you have a rational and factual understanding of what's going on. I think that's the standard nationwide. But fundamentally, to me, if I'm dealing with a client who you just are talking in circles, or you can't get in a word edgewise, or they're so distracted by something that you can't communicate with them, that to me is incompetency. And if you think about it like this, I mean, if I'm defending somebody, I need to know, okay, what witnesses do we need to call? Where was the knife? Where was the gun? Where was this? Where was that? Where was this person standing? Where was that person standing? Who said this? And if I can't even get a word in edgewise because they're so fixated on the chip in their head or something like that, then that's incompetence, right? Now, there's probably a lot more going on psychologically than just that. So being forgetful doesn't render you incompetent, but being forgetful may kind of diminish your. And it's in Latin. It's mens rea. That's my first year law school professor would be very proud of me.
Right.
But that's guilty mind, and so that it could tend to mitigate that.
And I want to get back to that mens rea with regard to intent in a second. We're talking to Jeremy Rosenthal, TexasDefenseFirm.com. So, when the special counsel includes a line like Joe Biden is a well-meaning elderly man with a poor memory, is it normal for a prosecutor, for a counsel to look at the likelihood of winning a conviction when determining a recommendation? Is that par for the course?
I think that would be a part of it, but they're people too, and so law enforcement, they do this all the time, and normally what we don't see is we don't have comprehensive reports like this that discuss, are we going to do this or are we going to do that? Normally it's sort of Joe Friday, just the facts. That's what your standard police report is. Obviously this is a pretty exceptional circumstance, so we're going to have a little more description here. But police can't help but sit across from somebody and think this person is pulling my leg or this person is not pulling my leg. This person, I really do think this person's trying to help me here and trying to point me in the right direction. I really don't think this person did anything wrong. Or to the opposite, no, this person thinks I'm an idiot. And so that's a very human part of a law enforcement analysis. Now, should it be? Hard to know. I mean, I think it's really hard to know when you're being lied to, right? So that part of it's hard to know.
Well, I mean, if there's a politician talking, they're lying to you. So that makes it a lot easier.
If their lips are moving, yeah.
Right.
So yeah, that ought to be the test. But yeah, if that answers your question, I mean, you do kind of, it's understandable that you would want a prosecutor to kind of engage in that kind of a quantitative analysis, right? Of what's really going on here behind the scenes. But it's a dangerous one because it's we let our emotions sort of get to us, right?
So let's get back to the concept of mens rea, a guilty mind versus intent, which factors into the degree to which you may want to prosecute a case like this. It seems to me that what the special counsel Robert Hur is saying in this case is that there was an intent, not necessarily to do anything wrong with the documents that Joe Biden kept, other than to perhaps memorialize them in a book, in a memoir. He believed he was able to keep the notebooks that he had. But when it comes to Donald Trump and those classified documents, the prosecution in that case seems to be saying that he had the intent to do something more nefarious with those documents, with that classified material.
This is where not watching all of the testimony probably hurts. I don't know if Mr. Hur talked about Mr. Trump or not, but yes, the issue, and I think the distinction that the Department of Justice would tell you in these two cases is one person did his best to, hey, here you go and right the wrong. Now, maybe there was intent initially to take and keep the documents. Maybe that was there. I don't know. But in the Mar-a-Lago case, I mean, we've got people who are moving boxes. We've got at one point, I mean, I think there's an allegation that, you guys throw the scent of the Department of Justice here, the National Archives, and there was a lawyer who was they weren't giving him the full story, or so the allegation goes. So I think that they would argue that, look, there's a lot more nefarious intent here. I mean, you guys are trying to pull one over here. I think that's what their argument would be.
Yeah, and as I'm going back through this, and obviously I think that the argument that the Republicans on the committee were trying to make is that there is a double standard. I think there's probably some truth to that. To the party in power wields some power and can tilt the scale just a little bit one way or another. I don't know that the Democrat from Maryland, Jamie Raskin, was able to win an argument making the point that Republicans were trying to get political gains from this hearing. But I also don't know that Jim Jordan from Ohio was able to win an argument that the reason Joe Biden kept the documents was to make money from a book. I think all of those arguments fell flat, and it just became a little bit of grandstanding on the issue of Biden's age and the hypocrisy of the prosecutions between Donald Trump and Joe Biden.
I think you're right. I think it's theater. I think that any time, and I'm not a political analyst, I'm a lawyer, but I mean, look, I mean, it's pretty clear that this is a narrative that Trump supporters and Trump would advance. And this is also an issue that Mr. Biden would rather avoid, right? I think
for a lot of reasons.
And I think if Biden has anything to be happy about, it's the fact that we're having this conversation in March and not on November the 6th, right? So it's politics, and that's kind of how it goes. From a legal standpoint, it is interesting because you've got similarly situated instances, and the things that differentiate them, at least in the minds of the prosecutors, are kind of what we've talked about, right? What's the intent here? Is there criminal intent or not? And is the crime when you took the documents, and if you did, were you trying to pull one over when you took the documents, or is it when you tried to, or was that an accident, or when the archives comes knocking and wants them back? What do we do then, right? Are we stashing them? Are we hiding them? Are we having other people help us? Or do we seem helpful? And is that seeming helpful sincere or not sincere?
I want to get to one more thing before we're out of time. Jeremy Rosenthal is a former prosecutor, now criminal defense attorney, founder of TexasDefenseFirm.com. How important is it to maintain the integrity and purpose of a special counsel, a special prosecutor, for cases just like this one?
It's critical, and if you will, it's in some ways almost a built-in flaw of our checks and balances, because the Justice Department is part of the executive, and we run into an inherent conflict of I don't know if conflict of interest is the right way to put it, a separation of powers issue when we have the executive policing itself, which is essentially what it is. So the theory is we take a special prosecutor and somehow he is detached from that. And so maybe it is and maybe it isn't. That's the whole issue, and that's a key. But making sure that you have competent special counsel, making sure that person is truly independent and doesn't have to answer to anybody but potentially a grand jury or a jury or a judge, that is very, very critical, because, again, in the separation of powers standpoint, fundamentally you have the executive policing itself, and that's just, there's just no other way to put it than that, and hopefully you just find the cleanest way to do that, because I think we would all agree that the laws apply to everybody, and if somebody's doing something illegal, then our system of justice says you answer for it.
Jeremy Rosenthal, TexasDefenseFirm.com. Great to have you on. I appreciate your insight.
Thanks for having me.